Hi, y'all, and welcome back. Welcome to tonight's third live stream. I've never done that before. I don't know if I ever will, but I was initially going to go do an interview that's been postponed. So we were right in the middle of talking about this bombshell new information in the Delphi murders case. And everybody said, wait, don't stop. And I had to stop. But now that I don't have to do that, let's finish up. Let's talk about the Ron Logan confession, because we, as you know, covered the Delphi murders case in great detail. I was up there. I stayed there for a month, went daily to the trial and covered that. There is a new motion, a brand new motion filed by the defense today, asking the court to correct errors in what happened in the case. They are arguing that there are 4 ways that that there were errors created, and they're asking the court to hear that. They're asking the court to give them relief, to give them a new trial. So we covered one earlier tonight. We covered what I think is probably one of the most amazing ones, which is the argument that they make in this motion that the white van that Brad Weber supposedly drove right by where Richard Allen was kidnapping the 2 girls, and that when according to a confession he made to his psychiatrist, Dr. Walla, he saw a van that caused him to change his mind. It startled him. He was going to R the girls, SV. I'm trying to use, appropriate lingo for YouTube. And that was what he was going to do. Changed his mind, said, I'm going to have to go ahead and just unalive them. That is what I'm going to have to do here. And so he then changed his mind, and that's why Libby and Abby were murdered. That was related to the confession, related to Richard Allen's confession. And I said on the previous live, I think that confession is unbelievably important. I thought it was the most persuasive evidence in the trial against Richard Allen. It was his own words, and it was said only after he was in prison. But one of the arguments that the defense has made is that more than one person confessed. The jury was shown only Richard Allen's confessions, but other people also confessed. And this new evidence is about Ron Logan. Ron Logan actually owned the property where the girls' bodies were found. And Ron Logan was initially considered a suspect. The FBI filed related to that. They filed a search warrant and an affidavit with that, explaining why they thought potentially it could have been, let me finish my sentence, they thought it conceivably could have been Ron Logan, and they wanted the right to search his property. Ultimately, he was not charged. He was not charged with that. He was charged with violating probation by driving when he wasn't supposed to be on the day that the girls were murdered, but he was never charged with that. But according to the defense, while he was in prison, he confessed to his cellmate. So Ron Logan actually confessed to his cellmate, Ricky Davis. It may be Richie Davis. I'm not exactly sure how to pronounce this. So if you know, be sure to put that in the chat. But let's go ahead and take a look at what the defense has filed and what they're arguing. This is an unusual way to present an issue around new evidence. The motion they've done it in. Do I think that they're very likely to win on this? I don't, but I think it's important evidence. I think it fits in with the third-party culprit evidence that was completely excluded, and I think it's important. So Richard Allen, as we know, was accused of killing 13-year-old Abigail Williams, 14-year-old Liberty German on February 13th of 2017. Here is the motion that was filed, and I'm going to show you specifically this section that relates to Ron Logan's confession. Ron Logan's confession to Richie, and it may be Ricky. In fact, I'll go with Ricky. I don't know which it is. If you know, please put it in there, and please bear with me as I say it wrong the whole time throughout. My apologies. Ron Logan's confessions to Ricky Davis before May 15th, 2017 is newly discovered evidence entitling Mr. Allen to a new trial. Now, there were already suggestions that Ron Logan had confessed, but they're saying that at least the details are new to them. Here's what is said. Dr. Core was the forensic pathologist who conducted the autopsies of Libby and Abby. His original opinion, held for years, about how Libby and Abby died was that two weapons were used. One, a serrated blade, and the other, a straight-edged blade. For the first time at trial, having had a eureka moment at his tool bench, Dr. Core opined that the girls could have been killed by a single box cutter rather than two different knives. Defendant's Exhibit 4A, as attested to by Matthew Hoffman in Defendant's Exhibit 4, is a redacted copy of a tip from the Orion database of tips dated May 15, 2017. In that tip, which the state has always had, Ron Logan is alleged to have confessed to Ricky Davis sometime before May 15, 2017, while they were in prison together, that he had killed Libby and Abby. The material part of Ron Logan's confession to Ricky Davis, as it appears in Exhibit 4A, is reproduced below. Logan confessed to Ricky step by step of killing the two girls. Logan told Ricky how he burned his clothes in a fire pit and where it was located, used box cutters, and struggled with one of the girls and thought drops of blood from his nose ended up on her clothes. Ricky also advised that he killed the older girl first. And there's a footnote here. Mr. Allen also said that he shot the girls in the back and buried them in a shallow grave. Neither of the girls were shot in the back, and neither was buried in a shallow grave. So what they're arguing then is it's not just that Ron Logan knew a lot of details around the murders and really could have committed these murders. It's also that Richard Allen's confessions didn't have the ring of truth because he was confessing to things that just didn't happen. Clearly, they say, he was coerced into this confession by the treatment he received in prison, the way he was treated, the conditions of his living while he was in prison broke him down, put him into psychosis, and his confessions were false. So they're saying Logan, on the other hand, confessed in detail, and none of the pieces of it were false. All of it was accurate. All right, so let's keep reading. Ron Logan's confession to Ricky Davis, as reflected in the tip in the Orion database and made a mere 3 months after the girls were killed, was detailed. Law enforcement followed up on the tip. Defendant's Exhibit 4B, as attested to by Matthew Hoffman in Exhibit 4, accurately reproduces the handwritten notes taken by Indiana State Police First Sergeant P. Hansard about his interview with Ricky Davis on June 21st, 2017, at the Newcastle Correctional Facility regarding Ron Logan's confession to Ricky Davis. These are very, very bombshells. So you are really going to be amazed hearing these. Those handwritten notes of First Sergeant Hansard are attached to Indiana State Police Detective N. Wolf's lead narrative summary cover sheet as it was provided to the defense in discovery. First Sergeant Hansard's notes of his interview with Ricky Davis about Ron Logan's confession provide even more detail. So essentially they're saying, okay, look at this is actual information taken down by law enforcement. This isn't something being made up. This isn't something that we are doing. Law enforcement wrote this down. Law enforcement talked to Ron Logan's cellmate, and this is what Ron Logan told the cellmate, according to the cellmate. Obviously, the prosecution will argue that this particular inmate had a whole lot of incentive. Maybe there was some promise made to him, and therefore he was coming forward and may not have been real. Ironically, it's usually the other way around when that sort of argument is made. Usually it'd be the defense arguing that the confession really isn't reliable because the jailhouse confession was made to someone who's also a criminal. But in this particular case, different. Hard as they are to decipher and subject to debate and correction, those notes reveal the following about Ron Logan's confession to Ricky Davis. Page 1 of Exhibit 4B is reproduced below. And they go ahead and translate what they think it says. And I'll go ahead and read that because it is pretty difficult to read the notes. Sometimes I didn't think they got it quite right, or sometimes I thought there was a word you could read that they didn't put down. But we'll go ahead and switch down to what they think it said, and maybe we'll do some more detailed work with this later. But in terms of this, these are the notes from the interview with Ricky Davis. Ricky Davis is saying Ron Logan confessed to murdering Libby and Abby. And here's what was said during the interview with the cellmate of Ron Logan. This is what Ron Logan supposedly confessed. Talking about knowing one of their dads to walk with them. One of them wanted to turn around, grabbed youngest's shoulder. It's okay. Oldest freaked out. One said something about calling police. S attack wasn't true. Originally not trying to go R them. Paranoid about probation. Felt like he crossed line when he grabbed the youngest one. Okay, so let's break that down a little bit and talk about some of the facts enclosed in that, because what they're saying is he grabbed that he was walking along with them talking and that he knew one of their dads. That would be a fact law enforcement could clearly check. That one of them wanted to turn around. He grabbed the youngest's shoulder. That would be Abby. She was younger and smaller than Libby. Said, it's okay. The oldest freaked out. One said something about calling the police. And originally he wasn't going to attack them. No SV was intended, but he felt like he crossed a line when he grabbed the youngest one, that he was paranoid about his probation. We do know he was on probation. Ultimately, that's what he went to jail for, was violating his probation by driving when he wasn't supposed to. The top half of page 2 of Exhibit 4B is reproduced below. The bottom half of the page duplicates the top half. It seems to say he started talking. Ironic. Should have been in school. Knew one of their moms waitressed at a bar, and I think that would be Abby's mother. Animals. Walked with them, willing to go check out horses, plus he X's. He told them he had rabbits in barn, walked through trail and woods, oldest paranoid, didn't want to go. Youngest wanted to see horses. So you can go back up here. And some of them like go check on horses. And he said, let's go back. Walked with them, willing to go check out horses. And then their translation of that is, they can't tell, they can't read that. And he told them he had rabbits in barn. Go check out horses, and he something. So they don't know what it says. They acknowledge, yeah, that's just hard to read handwriting. Okay, let's keep reading. The top half of page 3 of Exhibit 4B is reproduced below. And we'll go to their translations. It seems to say oldest turned to help youngest. Oldest started, they say, looking, kicking. We'll look at that in just a second. Youngest seemed, he now grabs oldest. He said he got hit on nose, scared he got blood on one of the girls, which would be critically important because it would mean there might be blood on their clothing that should have been tested or should have been found. Pulled box cutter out, slit oldest one, hit an artery. Youngest scared, etc. Took little girl with him for a while, never said where. He said he cut her to cut both necks. So let's go back and read this. So oldest, they believe, turned to help youngest. That would be Libby turned to help Abby. Oldest started looking. I think it probably says, I don't think it says looking. Talking, Oldest started talking. Youngest seemed something. I don't think it says seemed either. I'm not really sure. If you have any ideas, definitely put that in the chat. Oldest started as possible. Something, I don't know. Laughing. No, not laughing. There's no G. So, I don't know. He now grabs oldest. He said he got hit on nose. Scared he got blood on one of the girls. And that makes sense. In terms of, it looks like that's what it says. Pulled box cutter out, slit oldest. One hit an slit oldest one, hit an artery. Now, that actually there was a lot more blood of Libby's there. So, but also you would think that would pretty much be inevitable given what he did. But yes, I suppose that's possible. Youngest, scared, etc. Took little girl with him for a while, never said where. He said he cut, it's just pitiful, really. He said he cut her to cut both necks. I don't know what that means, but those are really terrifying details and really frightening. Now, how would he have known that they had slit throats? I don't know. It may well have been that the rumors passed around. There were a lot of this information was held very tightly by law enforcement, and not everybody knew it, but perhaps he knew it from allegations that were made or because he lived near the property or anything like that. There may have been rumors in the community that he heard, but these are pretty specific and pretty gruesome, definitely appalling. All right, let's keep reading. So continuing on, he left again, came back later in evening, search going on. Later on, late hours, tried to move oldest one to area not going to be found, place where four-wheelers something go, burned his clothes in burn pile, hiking, and they put question mark, walking, boots, gloves, bag. So yeah, it doesn't quite seem to say hiking, but kind of hiking. So let's talk about a little bit about what that might mean or what could be. Now, there was talk about how you may remember, he left and went to pick up fish. He went to a fish store that was a ways away. And by fish, I don't mean fish to eat. I mean aquarium. He went to the aquarium store and purchased some items and actually had a receipt for that. It was in the roughly, I think, the 4 or 5 o'clock range, and would have been after the prosecutors believed the girls were killed. Was he trying to create an alibi, get himself away? I guess they would argue that would be the case. So in this particular case, also, Libby's arms were above her head. And one of the witnesses suggested, well, maybe somebody was trying to drag her. Well, that actually would make sense. If it said he tried to move the oldest one to an area where they were not going to be found, maybe he grabbed her arms to pull her. Maybe he changed his mind and decided not to. It also might fit with the staged look of the bodies and the way the bodies were somewhat near each other if he actually tried to move Libby. So the place where four-wheelers go, I'm not really sure what that might be about, except maybe he was concerned the bodies would be discovered. He did nothing really to conceal the bodies, if it's the case that he did it, because there were sticks on there, bare sticks without leaves, just stripped regular sticks, and not any real attempt to conceal the bodies. At least from the photographs I saw, I didn't think it was. There was an argument from the prosecution, those sticks on the girls were to hide them. So hiking or walking, boots, gloves, bag. So I guess he's describing what he burned in the burn pile. That's extremely specific. And according to something said earlier, he actually said where the burn pile was. Again, giving the opportunity to law enforcement to go and look for that if they wanted to. Keeping on reading. I'm going to add the word could, because I think that first word is could. Could soles of boots be something in burn pile? Be located maybe in burn pile? In other words, I think he was worried, if this is true, I'm just going to we're going to, for a moment, put on the mindset that this is correct, and we're going to try to understand what the confession was. And then we can talk about whether it's realistic. So could the soles of the boots be located in the burn pile? One of the things this suggests is he was worried about being discovered, whether or not pieces of what he had taken off and was burning might be discovered. Next morning, 2 other girls knocked on the door, asked to search on property. Feel weird if he said no. He let them take off, got a hold of family member, and got out of area. So that's such a specific and unnecessary detail. You can see where if the cellmate planned to make up a story, maybe thought he would get some kind of advantage from doing that, he might well make up a story where he said, oh yes, in this particular case, he, committed the murder in this and that way. And he said, here was this motive, anything like that. But the idea that 2 girls knocked on the door and asked to search on the property, and it would feel weird if he said no, that seems so different. It doesn't seem like a detail he would need to add. And it seems like something someone would say. Of course, it's also possible that Ron Logan, if he were still alive, his attorney would argue, yeah, that he told them about what had happened that day, and they pulled out the one fact that was true and correct, which was 2 girls knocked on the door and asked to search his property, and he felt weird about saying, no, you can't look around on my property. So that it could be he heard that one part and he made up the rest. We don't have to say it's all or nothing. Okay, let's keep reading. The bottom half of the next page. First time he's seen them from property, home, etc., guns, etc. So there's a lot, as you can see, not translated there. It's hard to read what it says. Home, something, under the guns, under, etc., guns, etc. I don't know. Their translation is home, something, something, etc., guns, etc. And then it says, during struggle, youngest girl, something, not something, happened to friend, continued to stand there. Head, something, black, back, neck. They say artery. I don't think that says artery. I don't know what it says, but neck something. But thinking about in general what it's saying, he's saying he had not seen the girls before, that they're suggesting that he had guns in his home. And we know that is correct, that they looked at a gun of Ron Logan's and concluded it did not match the unspent casing. I think actually they believed it was, they could not confirm that it was. Unlike what they said about the gun they found in Richard Allen's home. They said, we can match that to the unspent casing. And they're talking about the struggle with the youngest girl. Some of this is just missed. We can't really see the words or know exactly what they are. And if you have ideas on what these are, please put them in the chat. I think everybody would like to figure this out. Happened to friend, continued to stand there. I think the word is continued that they miss there. So I think this, I guess what they're saying is once one was killed, the other girl continued to stand there as opposed to ran off. And I suppose that is true in that both were killed. Defendant's Exhibit 4C is a handwritten note signed by Ricky Davis dated June 21st, 2017, the same day First Sergeant Hansard interviewed him. That handwritten note is attached to the same lead narrative summary cover sheet and is contained in the same file as First Sergeant Hansard's handwritten notes. So here's what was written in this. Ricky Davis's handwritten note about Ron Logan's confession to him says, Mr. Logan has made reference to the killings in Delphi, Indiana. He told me he was the one who had killed those girls, that it got out of hand. He walked with them in the woods to his property, and the girls wanted to turn back. Said something about walking the something. He grabbed the youngest girl to reassure her it was okay. However, they panicked, and he also panicked. He indicated he ended up cutting the oldest with a box cutter. He went on telling me that he killed both of them because it was took too far. So let's think about one thing that seems to be missing in that narrative, though, and that's that they crossed the creek. The girls were on one side of the creek when they got to the end of the bridge. Then their bodies were found on the opposite side of the creek. And there's nothing in that. He talks about walking with them in the woods to his property. Well, he couldn't have done that. He would have had to cross the creek. And that seems to be missing in that narrative. So in addition to the other details that fit the known facts, Ron Logan confessed to Ricky Davis that he used box cutters. If instead of for the first time at Mr. Allen's trial, Dr. Corr said 7 years earlier that the girls could have been killed by a box cutter, there would certainly have been probable cause to arrest and charge Ron Logan. As it was, the FBI, 2 months before Ron Logan's confession to Ricky Davis, had obtained a judicial finding of probable cause to search Ron Logan's property. And we know that because that was sort of his introduction to the stage in terms of whether or not he might have been responsible for Libby and Abby's murders. And in this particular case, the defense is arguing, well, look, all along, if the expert had said early on that here's the tool that was used, box cutters, well, then everybody would have seen that this confession matched what Ron Logan, it would have matched the scene. Ron Logan said, this is what I used. And they would have said, why, look, that's exactly what was used, as the expert testified at trial. It was used as a point against Richard Allen because he would have had access to box cutters, like anybody doesn't, but would have had that in particular because he worked at CVS and as part of his job might have had the access to those. Under the circumstances, Dr. Corr's trial testimony about a box cutter possibly being used, I'm skipping words intentionally, makes Ron Logan's confession to Ricky Davis newly discovered evidence that would either be admissible through Ricky Davis or through First Sergeant Hansard under the Due Process Clause of the 14th Amendment. So let's pull this out and talk for just a minute. So here's the thing. When an appellate court looks back at what happened at a trial, they're going to say, if you already knew about this evidence, if you had that information, you should have made the argument at trial. You already knew about Ron Logan's confession defense. You should have made that argument. The fact that you elected not to make that argument is your fault. Now, especially not true here because the judge eliminated all third-party evidence. But in this particular case, they, I'm assuming, did not argue anything about the box cutters. They're saying the fact that a witness came to trial and for the first time said, hey, I just woke up and realized after looking at it that this is box cutters. And you may remember it was grooved. There was a section of marks on one of the girls that was grooved like the ribbed plastic or rubber handle of box cutters. And he said, I now see what that is. I believe that's the handle to box cutters. That's what was used in the murder. And so this particular new finding, they're saying, gives us a reason to argue that this is new, that this is different. No one had ever said before that it was box cutters. Probably the appellate court is unlikely to say that additional testimony changed it, but this is really important information that and Ron Logan, we already knew, had done something of a confession to someone inside, but this is very specific details, and I think it's super important. Let's keep reading a little bit. There are just a couple of paragraphs left. Okay, Ron Logan's confession exculpates, that means makes him not guilty, Mr. Allen, makes Mr. Allen not guilty, and or at least leans toward that direction, and would probably produce a different result at a retrial. Accordingly, the court should either vacate Mr. Allen's convictions or set this motion for a hearing. So one of the arguments that's going to be discussed is whether or not the defense should have raised this during the trial, whether or not they should have raised this before the trial, whether or not this should have been part of their argument when they asked for third-party culprit evidence. I think already the exclusion of the third-party evidence is significant enough that it is something that warrants a new trial. I think that third-party culprit evidence should have been admitted, and excluding all of it, just everything, I think that was a mistake. The kind of mistake an appellate court is more likely to pay attention to than if there had been a little bit, well, not this, but that. The fact that it was all pulled out, I think, will be important. But in this particular case, their argument is, okay, yeah, we knew about this. One thing that's interesting is they may have known about this, but these are details we didn't necessarily know. So it's new information to the public in a significant way, but in this particular case, not necessarily new to the defense. They actually knew some of this. They actually knew about this confession, but they're saying it became newly important. It became newly relevant once the expert came in and said the word box cutters. As soon as he said that's the weapon that was used, then that was the point at which Ron Logan's testimony, Ron Logan's confession became ultra important and should have been admitted. That was a reason alone for a new trial. That may be a reason for a new trial. This is a little bit strange of a vehicle to put it in, a motion to correct errors, but I think they really wanted to get this information into the record before it went on appeal. And I think they wanted also the information to be available to people who are evaluating the case. And I'm talking about the public in that particular case. So let's go ahead. I'll answer a few questions. And so if you would put question marks at the beginning, it'll be a lot easier for me to spot that in the chat because it goes pretty fast sometimes. Okay, so I am looking for questions, and while I'm waiting for the first questions to pop through, let's talk a little bit about Ron Logan. Now, he went back to jail when he was found to have violated his parole on the day of the girl's disappearance, February 13th, because he was driving around and he was not supposed to be driving around. So his parole was revoked. He went back to prison and he served a pretty substantial amount of time for simply driving, I think, without a license, and he wasn't supposed to be driving at all. So he served a decent amount of time for that, but he was never charged with murdering Libby and Abby. He has since passed away, so he cannot defend himself. So this is all we have is what this person claims he told them in terms of a confession while he was in prison. Annie K asking me if third party or new evidence should have been admitted. Is there a process that bypasses the judge on appeal? So the way it will work is that when it goes up on appeal, brand new judges will hear the case. Usually a panel of 3, although I can't say exactly how Indiana does it. So they will hear the case and they will only hear specific arguments. They aren't going to try the case again. There aren't going to be witnesses. They're going to get briefs from both sides. And that brief will have an explanation of why the defense thinks they deserve a new trial. It will name certain issues. We know some of them from right here. We know that they're going to argue Ron Logan confessed and it became newly relevant once the expert said box cutters were used. So that's going to be one argument they'll make on appeal. A huge argument will be that third-party culprit evidence was excluded and shouldn't have been. So those will be the kind of things that go up. The appellate court will look just at those issues, not a new trial, nothing more than that, just those issues. And when it looks at those issues, it's going to be asking questions like, could this have been raised in the trial court? And if so, why wasn't it? Or is this new evidence? Is this new information? Did the trial court make a mistake? Depending on what the issue is, they will be asking questions like that. They will make a decision. In something like 75% of the time, appeals lose. It might be more than that. But generally speaking, it's not going to be successful. Appeals aren't successful. In this case, I think the third-party culprit evidence is such a broad exclusion. I think it's more likely to be overturned than your average case. It's still probably less than 50% chance of it being overturned just because that's the stats. That this judge is going to hear this particular motion, and they've asked for a hearing, so there may well be a hearing. This judge will hear that. I think we can pretty much guess we'll deny it, and then it will be taken up to the appellate court. So that's where that's kind of how the sequence will occur. This judge will temporarily hear this and say no, yes, and then it will go up on appeal. A completely different panel will hear it. If it gets sent back, it could still be heard by this same judge. Typically, it goes back to the same judge. Judge Gull was specially appointed to hear this case because everyone in the county, all the judges, had recused themselves for being too close to the people, knowing too much. It just was not something they could handle ethically or appropriately, and so they asked for someone to be appointed. All right, looking for more questions after kind of long answer there to Annie. Where has this letter been? Carla wants to know. So these are notes taken during an interview, and this letter has been known, I think, to both sides. I think the defense is saying we had that, we knew about it, but we didn't understand the significance until the expert testified to box cutters. That's what they seem to be arguing here. That's how I interpret it. Jacob Monster asks if this is really Otham, what does that mean for Richard Allen confession? I think if this is really Odinism, is that what you're asking? What does that mean for the Richard Allen confession? Okay, I'll answer this question. This might be what Jacob Monster is asking me. So if somebody else is confessing, what does that mean for Richard Allen's confession? Well, it doesn't mean that the confession just gets thrown out. That isn't the way it works. Richard Allen's confession is still a confession. If the state retries him, let's say he got a new trial and the state decides to retry him, he still confessed. That's still evidence that they can present at trial. But what the defense always wants to do is try to convince the jury that there's a reasonable doubt, because the prosecution has to prove Richard Allen is guilty beyond a reasonable doubt. So if they can create that reasonable doubt, then they can hook a juror and they can avoid a guilty verdict for Richard Allen. So what they're going to try to do is say, okay, yeah, Richard Allen confessed, but so did, and they'll name various, because there were at least two other people, maybe three, who confessed. In fact, three who confessed. And they'll say, look, okay, he confessed, but so did these people. And law enforcement didn't pursue these people. So apparently a confession isn't always a confession. Sometimes the state may hear a confession and decide to believe it, and sometimes they may hear one and decide not to believe it. You, jury, are entitled to draw a reasonable doubt from that, because if more than one person confessed, who knows which one is the one who actually committed the crime. Annie, I forgot to thank people. Annie Case got her glass of wine, her feet up, bubble bath. She is ready to go. Yes, I'm glad we were able to cover this tonight and not have to wait. Oh, and Mama Pink's telling me, who has been a member for 11 months. Thank you, Mama Pink. She's one of our moderators, has been with me since the very beginning. And telling me Annie K had a super chat. But thank you, Mama Pinks, for being a member for 11 months. That's fantastic. Look at that. Glenda has been a member for 11 months too. That is fantastic. Thank you. That is exactly how long we've had members. So that is forever in channel terms. All right. How likely do you think this will bring it back to the court for briefing? Asked Amity. They've asked for a hearing. Interestingly, the judge had already taken these lawyers off the case. As soon as the trial ended and the sentencing ended, she removed them from the case. Not a surprise. There was no love lost there. But they have entered a special appearance just for purposes of these motions. And they said, Judge, you removed us too fast. There were some ordinary pleadings that we have to file that haven't been filed yet. So I would guess that she probably would I don't know if she'll give them a hearing, but I think she may accept a brief from the prosecution on this and then probably rule on it. I don't know for sure she'll have a hearing, but the defense has asked for one. So she may well do that. I don't know. Did Gull know about these facts before the trial? Jill asked. Yes, I believe so. I believe these were specifically argued in the third-party culprit arguments that took place the summer before the trial happened in October. Do you feel he may win on the appeal? Sherry Claiborne asked. I think he's got a better chance than usual. The normal chance would be pretty much no, but it's bigger than a snowball's chance in hell. Put it that way. Normally your chance is really small, but here I think he has a much better chance. I do think that like I said, the wholesale exclusion of all the third-party culprit evidence was a pretty big problem. I think also the attention around the case will force the appellate court to take a very close look at the details. So I think we'll see a very thoughtful opinion come out about it. I certainly hope so. Chloe's mom says his ex believes he did it. The FBI even had him on his radar. Doesn't that mean something? It did not. It did not mean anything when it came to prosecuting Richard Allen, trying him and convicting him, because the prosecution just didn't believe it. The prosecution apparently did not believe that Logan was involved, even if he did confess. And we don't know the background of that. Maybe this person who said Logan confessed to them is a serial liar who has repeatedly tried to buy his way out of prison by creating confessions. We don't know. Maybe that's the case. I think that the ex believing he did it might be something they would think about, but they definitely wouldn't count that against Ron Logan as evidence, because the fact that your ex thinks you're a bad person, that would probably be true for lots and lots of people. It's not necessarily something that would be evidence in a murder trial, because she might not actually know something specific to whether Ron Logan committed this murder, killed these two girls. All right, let's see. I'm looking for question marks at the beginning, because otherwise there are way too many for me to read through. I won't be able to figure it out. Sherry Claiborne wants to know, could he be innocent? I think that it's possible. I mean, I think that's what the defense is going to argue, and I think they want to argue that there's definitely reasonable doubt. You don't have to believe he's innocent to believe that there's reasonable doubt. I know that's hard for people to kind of grasp. It doesn't make a lot of sense, because you think to yourself, well, if he's guilty, I couldn't possibly have a reasonable doubt. But what if you're not sure? What if your doubt is like, well, I think he's guilty, but that's where the hardest case lies for a jury. And that's all they have to get to. They don't have to prove he's innocent, just that there's a reasonable doubt. All right, looking for the question marks at the beginning. Susie Hat asking, did the defense ever ask about the sticks from the scene? Were they cut with a power tool or just branches that fell off a tree? So we did not get at trial into heavy detail on the sticks. And I think part of that was because the judge refused to allow the defense to present the idea of Odinism and this cult ritualistic killing. There was talk about the sticks being on there, and that's about where it ended. There wasn't a lot of talk about where they came from or even whether there was a smooth cut. I think there may have been one question, something like, does that cut seem pretty smooth? Yes. But it wasn't something where you could really tell what the argument was. And I think that's because the judge had restricted it. Majestic Unicorn has also been a member for 11 months. Thank you so much. And can be added to the list for tonight. Thank you all. Look at this. Liz M. also. That is fantastic. Thank y'all. This is 11-month night. Thank you all so, so much. I'm glad to have had you around that long. That's wonderful. All right. Let's see. Sherry is full of questions, and I'm with you, Sherry. What does his wife believe? And I think you mean Ron Logan. I don't think he was married at the time. If you mean Richard Allen, she certainly has stood beside him. So I believe she thinks he's innocent. I guess we will never know that for sure, but she has not abandoned him or left his side. She showed up at trial every day. She did not come to sentencing, but she showed up to everything else. She did not miss. MB, anyone want to theorize about the Odinists or multiple people? So y'all have to deal with that in the chat. Okay. Looking for question marks at the beginning. We'll do just a couple more. MB, do any of these motions, which I get are at the trial court level, play into appeal? Yes, I think that's really their purpose, is to show more issues that then will appear on appeal. This is to put them into the trial court record so that they can go up on appeal. Now, the prosecution will still argue it's too late, that you could have put in this about Ron Logan. You could have at least argued the argument that this confession should have been admitted. This is nothing new. There's nothing changed about the fact that the judge excluded this as third-party culprit evidence. All of that was out. And the fact that one expert suddenly said box cutters doesn't mean anything in terms of letting third-party culprit evidence in. That's the kind of argument the prosecution is going to make. So, but yes, these will play into appeal. And I think these arguments will be made up on appeal. All right. Is Judge Gull, Susie Hat asked me, the one that would make a decision about the pleading about an error? Yeah. Yes. Motion to correct error is what it's called. And yes, Judge Gull would be the one who, this is directed to Judge Gull to make a decision on this. And then any of those issues can be taken up on appeal. The appellate court may say, too late, you should have argued this during trial. We will find out about that. They are very strict about that, that if you didn't make an objection and you didn't argue this or that, you can't suddenly bring it up on appeal. The reason being, as I explained in the first live stream tonight, the reason for that is they are concerned that somebody might take an argument, hold it back, keep it secret, so that they can spring in on appeal. Like, oh, this argument should have been made. Well, so the appellate court is very specific. You know, if you have an argument, you need to make it. If you have evidence, you need to put it in. If the judge keeps it out, you need to tell everybody what the evidence is. That is, I think, the most difficult part of the appeal for the defense, because I don't think all of the evidence got put in. I'm a little bit unsure because I wasn't at the hearing over the summer, and the judge allowed that evidence to be incorporated into the trial, so they did not have to present it twice. But frankly, a lot of evidence wasn't presented. So all of the third-party culprit evidence is not going to be in front of the appellate court when it goes up. The only evidence that will count is the evidence that was in the record at the trial court. And the defense is going to argue this was in the evidence of the trial court. That's kind of how the argument will be made. Prosecution won't agree with that. All right. Look at Spirit in the Night. No one questions the fact that the FBI was pulled out while they were on hot leads. There were hints throughout trial about a conflict between law enforcement and the FBI. And the defense tried to kind of break into that. Why was the FBI excluded? Who made that decision? When was that decision made? What was left out? And they were trying to sort of push the idea that the split between law enforcement and the FBI created this animosity, this animosity that had been created, meant that the FBI got locked out at a point in time and with evidence that might have really made a difference in the case. That law enforcement locally in the Indiana State Police did not take the evidence, the information, the help that the FBI could have provided. And if only they had taken that, maybe they would have found out who the real killer was. That's the defense argument. But they were not allowed to put very much of that in. We weren't really ever, that whole argument never really came out. And we certainly never had an answer to what happened to the FBI. Why were they on the case and suddenly not on the case? And there were even some times when decisions were made when the FBI could have done something easily and it just wasn't done because there seemed to be a reluctance to engage with the FBI. And that included some things like some of the DNA evidence. And it was frustrating to not have answers to some of those things that were pretty important. Veruca Salty. Okay. I'm having trouble reading that one. So there's more on Ron Logan than Richard Allen. Well, that's what the defense would argue to a second jury if they got a chance at a new trial. They would argue at least that, here's what you have on Richard Allen. Here's what you have on Ron Logan. At least you have a reasonable doubt about whether or not Richard Allen did it. So that's exactly the argument they want to make. And there was actually a comment in an interview of one of the jurors, the only juror who's been interviewed, and she said something about one of the jurors saying, well, I mean, there was no one else it could be. He was the one who was there that day. And she said to him, well, that's not the decision. It's not just who else could it be? It's also, is it that person? But the fact that the juror had that question will be effective on appeal, because I think that the appellate lawyers for Richard Allen will say, look, the jury wanted to know if anyone else could have been involved. The jury wanted to know, did a third party have the possibility of committing this crime? And if they didn't have the possibility of committing this crime, then that leaves Richard Allen. And that seemed to be what that juror was thinking. If there had been third party evidence in the case, that wouldn't have been a thought. That wouldn't have been something that would have even occurred to the person, because they would have at least said, well, it could have been this person or that person. I think it clearly was. And maybe they still would have decided Richard Allen was guilty, but it would have been with more evidence about the third parties. Chloe's mom asking me about my opinion. Because the case is still live, I have held off talking about that. Is there any federal movement to define reasonable doubt? Asks MB. I think that reasonable doubt has been established in the common law across all the states, and it really is pretty consistent in terms of how they define it. I don't think that there's any move to pull that away from the states or to change the way they have traditionally defined it that I'm aware of. I could be unaware of that, but I'm not aware of that. All right. Melissa asking me, how can Gull do this? Is this corruption or normal? So I'm assuming Melissa is asking me about the judge's decision to exclude the third party culprit evidence, the idea that other people committed the crimes. The standard that the judge uses when evaluating that looks at whether or not there's a reasonable basis for concluding that that person might have been someone who committed this crime. Now, Richard Allen has a constitutional right to suggest that other people committed the crime, but he can't just point to anybody and say, well, that person over there, they did it. There has to be some connection, a nexus, they call it, between what that person did and the crime. So there has to be a reason to think the two link together, hooked together. And so in this particular case, the judge ruled that she did not believe there was a nexus. There was no connection between this person over here and the crime. There wasn't a realistic way, a reasonable way that they could bridge that gap. So in this particular case, though, I believe that a lot of the evidence, there was at least a nexus, at least could be presented and talked about. The jury might have rejected it. The jury didn't have the chance to reject it. And that's where I think the problem lay. Hedgie Mom asked me why to think Kathy Allen wasn't put on the stand to verify that Rick was asleep on the sofa at 5:30 p.m. when she arrived home and his behavior was normal. So I had the wonderful opportunity to interview the lawyers for the defense. All three of them appeared on the show. It was a real honor, and I really appreciated them doing it. I still hope I will be given the chance to interview prosecutors. I would also be interested in talking to them. But in this particular case, what they were, I asked them about that. Why did you decide not to put Kathy Allen on the stand? So you can go back and hear their full answer and watch that video if you missed it. Super interesting. They did a really fantastic job. And as far as their answer was, essentially, they made the decision in the trial. That's what they thought was the right decision. It would have been very emotional, very difficult for her. And they didn't think they needed it. Would they make a different decision if it came back around? Maybe. And that's unfortunately true when you handle a case in court. You're making decisions. The best decision you can make. Sometimes you're going to be wrong. You just have to make the best decision you can at the time. In this particular case, I don't know exactly what she would have said. No one does. And so, I mean, his attorneys might, but we don't know. No one outside Kathy Allen and Richard Allen's attorneys know exactly what she would have said. Would it have been helpful enough? I don't know. Would it have been at least helpful? I assume it would have been. All right, let's keep looking for the question marks at the beginning so I can find your question. Claire's a Nightmare asked about whether Ron Logan was a known Odinist. I don't think so, but that's a very interesting question. And if somebody knows, stick that in the chat because I'm not sure about that. And let's see, I need to. Okay, so Kels has been a member for 2 months. Fantastic. Thank you so much. Janet, I can't remember if I had already thanked Janet, but she's been a member for 11 months, the full 11 months. Thank you. So many of you tonight. Perfect night for this. Okay. And Smiler VR is a new member. So glad to have all of you. Thank you for being with me. And Smiler, in fact, has a question. Did you see the court TV interview with private investigator Erica Morse, and what do you think about her shocking testimony? So her testimony was really important. There were parts of that, she maybe talked a little bit more in detail, but there were parts of that were already included in the Franks memo. So there was already information she was talking about out in the public, but she gave more detail. I thought it was really good, and I would highly recommend that to you. As far as what I thought about her testimony, I felt like we had covered that already under the Franks memo to some extent. She was talking about information related to whether or not, of course, Richard Allen was guilty or not, and to a particular law enforcement officer who had done research on Odinism and who was killed by a firebomb being thrown through his office window. So it was very dramatic testimony, and I think important. I cannot say whether it's really connected. I just don't know enough about it to be able to answer that question, but it's obviously extremely salacious. It is very significant. MB, I've heard from multiple law tubers that the confessions are going to be the crux of the appeal. How does the appellate court weigh that? Well, it's an unusual argument because of the argument that his confessions were coerced in the middle of prison. And the reason was the way he was treated, and it was barbaric, and it was inappropriate, and it was even against the rules of the prison itself. This long-term involvement in the long-term placement in solitary confinement was what sort of did him in. So as far as whether or not that's going to be the crux of the appeal, it may be. I'm not saying it wouldn't be important. I personally thought the third-party culprit was more important than the confessions. I think it's unlikely that an appellate court is going to look at the confessions and say, yeah, this environment was so bad, we're not even going to allow the confession to come in. I just think that's it's sort of subjective. And I think it's easier to say all of this evidence being excluded, that wasn't fair. I think that's more likely to be the ruling. But the confessions were a big issue. They are trying to increase the chances by pointing out that other people confess. If the confession, even under questionable circumstances, was so important it should come into trial, then why wasn't the confession of Ron Logan included? Why wasn't the confession of the other people who confessed? Why were those not included? And so those are the kinds of arguments that I think they're going to make on appeal. All right, I'm looking for question marks at the beginning. Would this go to an appeals court and ultimately to the Indiana Supreme Court? Yes, Jerry, that's it. At least in my state, that would be the progression. So I think that that's how it would be in Indiana as well. I will say that the Supreme Court has already had some involvement in this case and heard some issues. I don't know if they would skip the Court of Appeals for that reason, and go straight to the Supreme Court, but they were involved in some of the issues. So I don't know. Constance Phillips wants to know, so Ron Logan was in jail. Yes. And this had to do with a violation of his probation. And it was related to the day of the event, but not necessarily related to the event itself. And by event, I mean the murders, disappearance, and then murders of Libby and of Abby. So Jim Chrisman wasn't one FBI guy shot and killed. That's the testimony we were talking about earlier, or the interview given by Erica Morse was talking about that issue related to the FBI. I think it was local. I don't think it was FBI, but he was in his office. He had done research on Odinism, and he was, I think it was a firebomb thrown through the window, and he was killed rather violently as a result. All right, looking for questions. You have to put the question mark at the beginning or I will never find it. And okay, here we go. Chloe's mom. The jury question forms were sent out and the Odinism was on there. Then Judge Gull ruled against it. She said she was waiting for Odinist connection and never heard it. I really thought she had ruled before the trial started. Now, it may well have been on the forms because in case it came in or anything happened, they wanted to make sure that got pulled out. Also, the defense lawyers in particular would need to know, because if there is this argument about Odinism and Richard Allen is potentially connected to this, Richard Allen is not an Odinist, but Odinists may have been involved. So if he's convicted, or isn't convicted, maybe then they go after the Odinists. That sort of problem is what Judge Gull is why the defense would need to know whether or not any of the potential jurors had a connection to Odinism, because they were thinking the Odinism, if anyone's connected to that, they may be thinking we're about to get away with something if only Richard Allen is convicted. And so they might have a vested interest in that. So that might have been a particular interest to them. Maybe that's why it was on the question form. Last one. Didn't Allen tell his wife he committed the crime? Sherry Claiborne asked. Yes, he did. He also told his mother that, and he said that more than once to his wife. We heard or were read some of those confessions. They were done by phone in the prison. Then we also heard, or actually read, the confessions to the guards, and where they had taken notes and written out what they had. There were many of them. I think 20 something were presented at trial. Not all of them were presented at trial. There were some that were made to inmates. Those were not included. The ones made to guards were included. The ones made to the wife and to the mother were also included. All right. So, well, I'm glad we got to finish that up. And so I'm glad for that. I want to say thanks to Marlon, Mama Pinks, and Denisepelton, who have got to be exhausted by now. Thank you so much. I'm really grateful. If you aren't following the Natalie Cochran trial, you are missing out. We're covering that every night. This is a pharmacist who's accused of poisoning her husband by giving him a shot of insulin. But it's not just that, because before that, she was accused of a Ponzi scheme. She pled guilty to that. She's serving 11 years and 3 months in federal prison. And the prosecution says the reason she killed her husband was he was about to find out about and maybe even expose her Ponzi scheme, in which she ripped off her own parents, her brother, and took all the life savings of his parents, her in-laws. That's the allegation that was made. She pled guilty to at least the fact of the scheme where she took money and ultimately did not have the government contract she said she did. There are also allegations around whether or not she faked cancer to try to get away with some of the statements that she made, like, oh, I can't get your money, I'm so sick with my cancer, for example. And those kinds of statements are included in the case. It is a wild case. We are following it day by day. And so by all means, hit the subscribe button and come back for more. Tomorrow night, we'll be covering the Natalie Cochran case. We're going daily on it. Fascinating case. Fascinating case. I do need to say thank you to Jessica. What were the oddities that drew you to Delphi? It would be, without question, the Frank's memo and just all of the facts that were put into that. I thought it was phenomenal. It was really interesting. I thought it threw a lot of doubt into it, and I wanted to know more. I also thought the fact that when the lawyers got kicked off the case, I thought that's just wrong. They had done a fantastic job on that brief, and I thought these are the kind of lawyers that, to make the system work, you need great defense lawyers who really passionately pursue their client's case, and that's who these lawyers were. So that was really what drew me to the case. So I'm glad that we did so many lives tonight, because I get the chance to show you a very special outro that was made by our moderator, Marlon. It's my husband died on May 8th, and yesterday would have been his birthday. So Marlon made me this super special outro. I guess this will be the last time we play it until May 8th. So this is, and he really looked like this, handsomest man ever.